Thank you again for tuning in. For those of you that just signed on in the last few seconds, let me reintroduce myself. My name is Amina Poricanin. I'm an attorney with Poricanin Law, and I have the pleasure of being joined for today's presentation by Charlotte Rafus, another attorney at our law practice. Thank you for those of you that have taken the time to tune in. This is actually an overlooked but extremely important provision of running any sort of business. And more, we are getting involved in resolving issues that have some root or connection to a services agreement with what we have referred to very broadly as a vendor. They are either a 1099 individual or they are a business who is doing some sort of business with your home care agency. There are a lot of things we will talk about today that could apply to non-home care agencies for those of you that may have other lines of business. But we will also make sure to cover things that are specific to providing home care services in the contracts that you may have with all of the different vendors. Again, either 1099 or entities who are in some way related to your operations. So with that, let's just talk about generally kind of what the presentation today will cover. We're going to talk about the types of contracts we see often related to home care. We're going to talk about vendor and consulting agreements. And so vendor, consultant, third party, provider, these are all general terms that are referring to an entity or an individual outside of your business, someone who is coming in under a contractual relationship, not a legal obligation, but they have a contractual relationship to provide services to your business. So we'll talk about some of the most common agreements. They could be with marketers or marketing companies or business development companies. Offshore, on-call services. They could be arrangements with payors, MLTCs, and what those contracts require of you. So there are some general terms you will see that apply across all contracts, and then there are terms that are more specific to the nature of services that you're providing as a home care entity. We will talk also about the legal, regulatory, and business risks that arise from these contracts. We will talk about the specific and kind of unique emphasis that you need to have in relation to these contractual relationships because you take public or government money. So whether you are billing Medicaid directly through fee-for-service or through MLTC or an MCO, or you are a Medicare, primarily Medicare-funded business, or you have contracts with the HRA or the DSS. There are all sorts of Medicaid or Medicare type of contracts. Those are all government money. And there are conditions to taking the government's money to providing services. And some of those conditions either have to make it in your contract with other third parties, or your contract with that third party has to be written in mind with those obligations and commitments you have made to your payors. So we'll talk a little bit about that as well. And then we will talk about where the liability is. Like I said, the reason we're having this webinar is because we often have clients who come to us after things have gone wrong with some sort of a vendor or a provider or a contractor, or they have been audited and the contract came up. It wasn't even the main issue of the audit, and the contract came up, and now that's part of the liability that the business is facing. So we're going to try to cover all of these topics with you today. Okay. Now, objectives. We want to make you more aware of what the regulatory and legal considerations are. It's just a 1-hour webinar. There's too much for us to cover, but we will try and do the best we can. Obviously, there are regulatory concerns. All of the licensed providers, whether they're LHCSA or some other licensed entity, as a condition of the license, as a condition of being able to provide the service that they do, they make commitments to New York State. And these are not a one-time commitment. It's not a one-time contract. The license itself is subject to revocation if the provider doesn't meet those conditions of being a licensed provider. And so at all times, those conditions there's a contract with New York State, basically. We, the license holder, will meet these conditions that we have put in our application and which you have approved. And in exchange, you, New York State, will allow us to continue doing the business that we have. Now, there are, in the course of becoming a licensed provider, many of you who have had a management or a consulting agreement, which is a bridge sort of agreement that allows someone who is not licensed to provide licensed services. And so the state prescribes what has to be in those agreements. So keep in mind, we do have vendor agreements with entities that are entirely regulated by New York State. The state tells us what has to be in those agreements. And so when we're doing transactions and we are representing either a buyer or a seller of Alexa, and there is a potential new owner coming in and we're reviewing these contracts, we always have a conversation that there are, at a minimum, provisions that have to be in a management or a consulting agreement in order for it to be valid under the law. It doesn't matter that the parties have signed off on it and agreed to it. If the contract doesn't contain the terms that the state requires, the contract is void. And what does that mean if it's void? Well, neither party actually has to abide by it. And the state doesn't have to recognize the new entity as the operator of this licensed business either. So all sorts of implications if you don't follow what the law prescribes as the obligations. Now, there are also referral, kickback, and false claims issues that come into play when we are dealing with healthcare entities who receive government money for their services. And we'll talk a little bit about that. Key contractual provisions, like I said, it is a 1 hour webinar, and I'm sure you have all received at least a cell phone service contract in the past that has a bunch of boilerplate provisions. We will try to do our best to go through the key ones in contracts like that. We'll talk about offshore work considerations because those are pretty common. These types of offshore or sending work to be done abroad is pretty commonplace. And for healthcare entities, obviously it raises PHI and cybersecurity concerns, but there are also contractual concerns. And again, there may be restrictions on what work can be offshored, where information can be stored. And once again, because it's government money and the government gets to dictate the conditions, there is the possibility that if you don't meet something as simple as an offshore contract requirement, your billing could be subject to recoupment by the federal or state governments. So it's all intertwined. That's why we have to make sure we're checking all of the boxes on these contracts. Now, last but not least, we will touch on privacy and security issues, not just as it relates to PHI, HIPAA, breaches, all of that, but as it relates to business concerns as well. Who has access to the Coca-Cola secret recipe of your business, right? Where are you sending that? Who are you sharing it with? Under what conditions? And how are you protecting it? How are you making sure that someone is not going to run away and replicate your secret sauce? Reverse engineer it. Reverse engineer your software, your processes, the essence of what makes you the business. How are you protecting that in these contracts where you are delegating to another entity, an outsider, certain key tasks of your business? So that's what I mean about privacy and security, and we'll talk about that a little bit here as well. Okay. Why when vendor agreements matter? Well, we've been kind of talking about that already, but let's just go through this here. At the end of the day, most of you who are on today's webinar do receive some government money in exchange for providing services that you do. And so your contracts and your ability to receive payment for your services have to comport with legal requirements. There are a number of those requirements, and the contract cannot be written in a way that avoids them, number one. In fact, for licensed agencies, services agreements are subject to review at the time of relicensure surveys. I mean, if you had any doubts about what the DOH is thinking about or why they're looking at this, that should tell you. They want to make sure that you're running that licensed agency in accordance with the license that was given to it. And a licensed home care services agency can only provide certain types of services, and some jobs it cannot outsource. And so the surveyors are asking for your vendor agreements at the time of survey because they want to know what work have you sent out of the company? What work have you given to an unrelated entity or individual beyond what we've told you you have to do on your own? So vendor agreements are important because they could jeopardize your license status and your ability to be the business that you are, number one. Number two, if you're not doing them correctly, they could jeopardize your ability to bill and keep what you have billed for your services. Number three, at the end of the day, kind of related to the first 2 points, there are some things that cannot be outsourced. Even though you may legally outsource them, for example, a compliance duty, you can outsource it. But the responsibility for any errors and for ensuring that it's done correctly still resides with the agency. And you cannot contract that away, by the way. You cannot put in the agreement that, hey, you entity or you individual, have you agreed to be our compliance officer? And so we are okay. We've met our obligation to provide a compliance program for our LHCSA. It doesn't work that way. Again, there are some duties and obligations that cannot be contracted away, and irrespective of the titles that you give to this outside vendor, i.e., they're going to be our compliance officer, the responsibility and all of the consequences still reside with you. And so it is very important that when you, as a provider, think that you're delegating some responsibilities to a third party, you appreciate that you're not really delegating it. Okay. It doesn't matter what it says in that written agreement. By matter of law, the responsibility stays with you. And worst, the consequences stay with you. Medicaid integrity, that kind of goes hand in hand with the compliance work. Ultimately, the provider is responsible for a lot of these essential functions that a healthcare provider entity provides, such as the conditions of participation in Medicaid, such as ensuring Medicaid integrity, such as ensuring HIPAA compliance and corporate compliance program is actually effective and executed and done. So, again, the agreements are important because they have to be clear that you are not truly outsourcing this responsibility. It stays with you. And putting anything else in there just creates a false sense of security that unfortunately we've seen providers face the consequences of. They think that because they're hiring an outside vendor to run their HIPAA program, for example, to be their privacy and security officer, or they've hired an outside vendor, a specialist, to be their compliance officer, or to do quarterly audits of their billing. They think that they have satisfied their legal obligation to the state of New York. They have not. And it is a rude awakening when they realize they're responsible for all of this work that they thought was being handled elsewhere. Vendor relationships do impact compliance and patient care. It is not just about signing a contract and saying, okay, we have to do XYZ as a LHCSA. We've sent it to so and so, so we're now good. For all of the reasons I mentioned, it does ultimately come back to the provider. And then lastly, operational and financial risks must be managed proactively. Like I said, there is this false sense of security that because you've outsourced the work, you've delegated it to an entity that holds itself out as a professional in something, that your responsibility to oversee it and do it correctly is somehow also delegated. That's not the case. The financial risk always stays with the business owner. And not just because they are a home care agency, not just because they bill Medicaid, not just because they have a license from New York State that is revocable. The responsibility stays with the business because that is the nature of the American capitalism business world. The responsibility is always with the deep pocket. We can go beyond home care and talk about just general slip and fall or other accidents and cases where a business gets sued versus an individual. Plaintiffs are always looking to sue the individual or entity with the deepest pockets. And typically, a business has deeper pockets to pay liability and to be blamed for things that go wrong than an individual. And so, to avoid just general liability and to avoid being sued for general business things, um, business owners have to appreciate that the liability really cannot be outsourced. The risk has to be managed internally. You cannot just delegate it contractually to another party. Okay, anti-kickback and referral concerns. So this one comes up a lot because we do have quite a frequent opportunity to review marketing and business development agreements with individuals or those individuals' entities. They're often solo member or solo shareholder entities that provide all sorts of patient or employee development services. And so there is this common structure in the home care industry where marketers have gotten used to being paid on a referral basis. And there are federal and state anti-kickback laws. There are federal and state False Claims Act restrictions that prohibit the incentivization of someone increasing the cost of providing Medicaid or Medicare services. So, general advertising is okay. General business development is okay. What is not okay is incentivizing someone to make money and be paid strictly on productivity. And productivity is measured by how many people or hours they bring to the table, i.e., to the home care agency. So, what we refer to as referral-based compensation is that you bring me life with XYZ hours or some hours, and you, the procurer, will be paid a reward for doing so. That is inappropriate under federal and state laws. Now, there are safe harbors for that would allow a business development person to be paid and rewarded for results, but it is in the context of a number of other factors. Certainly, it's in the totality of the relationship between that individual, the marketer, and the healthcare business that has engaged them to provide the service. For example, it has to be a 1 year employment arrangement whereby the marketer is working for this entity, developing their business. And if they are successful, they may be paid a bonus or a commission, but they also have to be paid for their time and effort. Their compensation cannot be strictly tied to productivity or to the number of patients that they're bringing back to the employing entity. And so this means that it is a W-2 relationship. It is not a 1099 relationship. And so one of the first red flags we see when we're asked to review a vendor contract for marketing services is that it falls outside of this safe harbor structure because it is not an employment relationship. It is instead a month-to-month marketing contract where an individual or their firm is being engaged to provide business development services, maybe in a certain community, maybe in a certain geographic region, and in exchange, they will receive, if anything, a monthly bonus or a commission. And if they don't work out, they will be let go. So these are what we often see. And we've seen some very creative ways to make these look legitimate. But depending on who is in the White House and depending on what state we're in, it doesn't really matter what label we put on it. What will ultimately matter is what is the intention and how this actually functions. I should also mention that there are a number of these arrangements that are not even documented. We are made aware of an arrangement that was negotiated verbally and that is in practice, even possibly long-standing practice. And it is not codified or written down anywhere. We just are made aware of it verbally, ideally under attorney-client privilege, although sometimes we're told these things outside of attorney-client privilege. And sometimes these situations do get prosecuted. A lot of you in this industry are aware of social adult daycare centers being a hub and kind of a breeding ground for these arrangements, sometimes between related entities, related individuals. It doesn't matter. It is only a matter of time before these get caught by either the federal or state regulators. And because the industry is so competitive, there are often reports against competitors, providers calling in on one another. I see some questions popping up. I just want to say that we will try to address those at the end, just to make sure that we do not run out of time. I'm supposed to turn this over to Charlotte on slide 7, but Charlotte, you're going to pop in because we don't have numbers. So you're going to tell me when it's slide 7. Just for your own knowledge, because at the end of the day, we don't expect you to memorize all of this. Just be very sensitive about the fact that there are parameters about how and what you can pay to someone who is bringing you business. Now, when we talk about prohibited payments for referrals, we're talking about patients. You are allowed to incentivize the recruitment and growth of your employee ranks. And so you can pay a recruitment bonus or a referral bonus to someone who brings a friend or a family member as an additional employee to the company. What is not allowed and what you have to be very careful about, for example, in Consumer Direct, when it was a bigger program than just the single fiscal intermediary, bringing a patient meant also, I'm sorry, bringing a caregiver to an agency meant that a patient was likely to come as well. And so it was a bit of a circumvent way to pay someone for bringing a patient to an agency. Supposedly, on the face of it, you were paying for another personal assistant coming to be employed. But if that personal assistant had to or did come with a patient, you were effectively paying for the bringing and the referral of a patient. Okay, let's talk about when you're looking and considering these arrangements with outside entities. We want to talk about, at the first step, making sure that you're hiring someone who can legally do what you're hiring them to do. Let me give you an example. For those of you downstate in New York State who are now preparing the LS 300 and the 301 forms, and you have to have those audited, there are a lot of entities who claim to be auditors or accountants, and they are not. Okay? Make sure that you are hiring someone qualified to do the service that they specifically have to be qualified to do. Now, there are some vendors that you can hire without qualification. It's a bad business decision to hire them without a qualification, but it's not unlawful. For example, you don't need to hire a marketer who has a marketing certificate and who went to a marketing school. However, in order to certify on the LS 300 and 301, you have to have an audit and review done by someone with the proper credentialing. Otherwise, your certification is invalid. So, I've spoken to a number of providers who have not taken the time and done the due diligence to make sure that the auditor that they're hiring, who is carrying themselves out as an auditor, as a financial person, is actually licensed to do this. Not to mention the fact that we're admitting all sorts of things to these folks outside of attorney-client privilege. Make sure you're doing your due diligence to confirm that if you're hiring for a job that does require certain credentials, that the person you're hiring does have those credentials. We as lawyers are allowed to carry ourselves as lawyers. But for example, a bookkeeper can say that they're an accountant and sell themselves out as an accountant because there's no law that specifically prohibits them from saying that. It would really be up to the Attorney General to prosecute that bookkeeper for false advertising. But outside of that, there's no authority that is actually going to clamp down on that bookkeeper and say, you're not allowed to tell people you are an accountant when you're in fact just a bookkeeper. So make sure that the vendor you're looking to retain for any sort of work has the actual legal authority to do the work that they're doing. Because, as I said, there are some jobs where a license is required to do that work. If you have a lawsuit and you need a lawyer to appear in court, you have to hire a lawyer. If you have an EEOC charge, for example, you don't necessarily need a lawyer to appear for you at the EEOC. You could have a non-lawyer prepare a position statement. So, but a judge will not let you submit something that a paralegal has written or signed. So, depending on the authority that you're before, that is imposing conditions on you or that is requiring something of you, the vendor that you hire may have to have a certain license or authority to do the work that they're doing. I want to talk about some of you who may provide companion care, nursing services, assessments, evaluative, occupational health. There's all sorts of nursing services. So these are the ones, with the exception of companion care, that actually do have to have a license. And so we regularly advise entities who want to become a professional corporation about whether they can become a professional corporation and who can own it, who can set it up, what professions can commingle, if at all, in a single entity and which ones cannot. Because if they are not organized properly, if a PC is formed by individuals or professionals who, well, it will never be formed, but if individuals try to advertise themselves without the proper credentials from the state of New York as a professional corporation providing XYZ healthcare services, that will be an unlawful practice and they will be shut down. And all of the patients for whom they have provided services under false pretenses, saying that they are a professional corporation, can sue that entity. And there's no waiver, there's no valid waiver, the type that patients may sign when they go see, I don't know, a Botox dispenser, let's say. There's no valid waiver they can sign that will relieve that business of liability for carrying itself out falsely as a licensed provider. So make sure that if you are referring any sort of work, because home care is very entrepreneurial. A lot of you are home care agencies, but you're other things as well. And I know you have agreements to provide different services through entities that maybe you have a joint venture with, maybe you have a services agreement with, or some sort of a management agreement with. Make sure that the entity that you are partnering with is licensed to do what it is saying it can do. Companion care is outside of the DOH framework. The DOH will regulate companion agencies if they're holding themselves out or actually performing licensed home care services. But technically speaking, they do not exist under the DOH's regulations. They're outside. And that is why they are not considered a healthcare service. And then unauthorized provision of regulated services and licensure and credentialing concerns. We've talked about that. It really boils down to if you are providing services or contracting with someone to provide services that they're not licensed to do, it is a risk on multiple levels. It is a risk that may be financial, may be liability based, you get sued, or you get shut down and not allowed to continue providing your business because you're carrying yourself out as being a licensed XYZ provider, and you're not allowed to do that. So you may just get shut down and then be made to pay back everything you've billed, and you may be sued for all of the damage you've caused or simply damage you caused by providing services and causing stress to people, right? Telling them that this is an extreme example, for example, but someone is doing surgery, but they're not a surgeon, right? And so maybe the surgery was done correctly, there's no actual harm, but the fact that it was done on someone under false pretenses, the patient never gave valid consent to be operated on by someone who's not properly licensed. And so that patient has a claim against that person who was pretending to be licensed as a surgeon. Again, I recognize an extreme example, but it just makes the point that even though there's no actual physical harm to the patient as a result of the misrepresentation, that patient does have a claim and damages that could go back. Okay.
I can take this one over. The scope of services. Thanks, Mina. So in your agreement, you want to make sure that you are defining what the deliverables are clearly, because this is really the foundational question for each of these vendor agreements. Before you sign anything, you need to be able to answer in plain English, what exactly is the vendor doing for my agency and what am I getting in return for the money that I'm spending? And this matters for two reasons that are specific to home care agencies. The first being that for many of you, a significant portion of your revenue comes from Medicaid, which means a significant portion of what you spend comes indirectly from public funds. So the regulators will scrutinize your vendor relationships and your expenditures. And if you cannot point to a contract that clearly defines what a vendor is doing and why, then you have a problem justifying that expenditure. And second, from a pure business standpoint, if your contract does not define what the vendor is supposed to deliver, you really will have no legal basis to complain when they do not deliver it because you can't enforce something that was never specified. So when a vendor says they completed their obligations and you say, no, you didn't, the contract is going to be the first thing that both sides will look at. And if your scope of services is vague, the vendor will want to point to that language and say they did exactly what was required. And you want to be able to make sure you have some sort of basis to push back on that. In terms of performance metrics, these really turn the scope of services into an enforceable obligation. So those metrics should be specific and measurable. So, for example, if you're hiring a staffing vendor, your metrics might include the fill rates for open shifts, response times to urgent coverage requests, the percentage of aides who complete required training on time, stuff like that. If you're hiring a billing vendor, your metrics might include claim submission turnaround, denial rate thresholds, and collection rate benchmarks. And if you're hiring a compliance consultant, your metrics might include the completion of quarterly reports or the conduct of scheduled audits and the delivery of a written risk assessment by a certain date. So overall, you want to be able, again, to point to these specific and measurable metrics. Um, if and when any question comes up and the vendor is trying to push back. Your agreement should also give your agency the right to audit the vendor's performance and should require the vendor to provide quarterly reports on their activities because the audit rights give you the ability to verify the vendor is actually doing what they say that they are doing. And the reporting obligations create a paper trail that demonstrates your agency's oversight, which is exactly what regulators like OMIG would look for in a compliance review. So, at a minimum, your vendor agreement should include a right to inspect relevant records on reasonable notice, a requirement that the vendor report any material issues or failures promptly, and periodic reporting obligations, whether that's monthly, quarterly, or whatever is appropriate for the nature of the work.
Thanks, Charlotte. All right. So kind of going back to what we had talked about earlier before you sign, obviously trust, but verify that the provider that is negotiating with you to obtain your business is who they say they are and that they can deliver. All sales vendors say one thing during the pitch, but the small print in the contract is what ultimately governs. And there is often a disclaimer that says nothing we have said up until this point is actually valid. All that we are committing to you is what is in this black and white print in this contract. That's it. There's no other representation, guarantee, other than what is in this contract. So do not go off of what they have committed to you verbally during the sales and the dating process, right? Look at what is in the contract before you sign to fully appreciate what it is that you're actually buying, agreeing to, and what you expect from them. It is not unusual to ask for references, and you should. Google is not always the most reliable reference source. So be free to ask, how long have you been in business? And give me the names of your oldest and youngest customers. And I'd like to be able to reach them. And then review insurance and financial stability of the vendor. Now, this is where things get bad. If your contract specifies either a limit on damages or it has no limit and you can recover all of your damages, all that is great and dandy. But if they are not financially solvent to pay for your losses, what good is a contract? So all of the pretty language in the world doesn't take away the loss that you experience if you've suffered damages and no one is there to pay for your liability. For example, you hire a marketer, uh, putting all of the anti-kickback and false claims and anti-referral restrictions that we talked about earlier. You hire a marketer to develop one line of business for you, and that person brings in their employees. Let's put the labor considerations aside, but they are working in your business day to day, and they're there for a year, and they really do build out this line of business for you, a division on its own. I don't know, pediatric home care services under XYZ contract in ABC County. Let's just say it's that niche area. They decide to leave and they take all of these folks with them and they relocate somewhere else in another agency. And they are judgment proof because they've set up their assets so that when you sue them, there's nobody home. There's no money to claim from them. So you have a contract with this marketer. They've done their job. They left. Maybe they left prematurely on bad terms, whatever it is. They were not supposed to take the business that they built. They did. And now you're at a loss. You've paid the vendor for a year. You've paid their employees. You've invested a lot of time and money to build out this line of business, and it's gone. Who do you sue and what do you actually recover? We often have this conversation actually with businesses. Like I said, LHCSAs are very entrepreneurial. But this is an example, another one where a LHCSA trusts an outside party quite a lot with its business, with its secret sauce, with its processes. It leaves itself vulnerable. And people are very mobile and they can leave and they can replicate what they have done for you for your competitor. So at the end of the day, you've spent a lot of time and money building this out only for it to leave, and then you have no recourse. So when you're getting into these relationships, whether it's a vendor or a potential long-term partner who will be working in your business day to day on something as significant as developing a specific line of business, you have to think about this option. What happens if they end up being a real jerk and they take everything I've entrusted them? How do I make myself whole again? How do I recover from that financial hit? Now, insurance is a big one, obviously. Make sure you're speaking with your broker about what type of business liability or loss coverage you can get for these types of circumstances. Maybe some sort of a security deposit, maybe a promissory note, maybe some sort of collateral that you record, something that will be pretty irreversible, fixed, and solid, financially solid for you to latch onto if you have to, if the worst case scenario materializes. It's a lot of work at the front, And a lot of companies get into these business relationships with the best of intentions. Nobody plans for this type of a catastrophe, but it does happen with some regularity. And so that's why we're talking about it today, that you really do have to approach your business in that protective mama bear type of way. The other thing you could do, aside from obviously make sure that they are a good person at the end of the day. Not only that they're good business people, but do they have integrity? Are they honest? Are they going to be good people? Or are they going to be a jerk? Just a simple jerk. Like, who does this? You know? Um, but then also check litigation and what's on written about them online. If they've been sued before, there's a lot of publicly available information that will outline the course of someone's business dealings, right? And you can get a sense of, are they fair? Do they play fair in business dealings, or are they, someone who is just a little too sly? Do your research. Like I said, ask for references, trust but verify, and then still get that insurance policy, either an actual policy or some sort of a collateral or security into something financial and concrete that will either hold the other side straight because they know you have that collateral, or they will not hurt you as much because they know it's going to hurt them as well, for them to lose that collateral. All right, compensation structures. This is in line with what we discussed earlier. I do suggest that if you do have arrangements that have to deal with business development and that pay any sort of incentive or reward, whether you call it a bonus, a commission, incentive, the labels really don't matter. If they are tied to productivity, have a lawyer look at it and advise you, because these not only have criminal, but they have civil implications. And then the thing is, there's two parties to an unlawful agreement like this, but if you get the short end of the stick and then a lawyer later tells you, well, you shouldn't have entered into this contract in the first place, you're also kind of stuck wondering, can I even report this? Because the regulators could turn against me. I was the victim in this arrangement at the end of the day, but at the beginning, I was the one that went into it as well. So do I actually raise my hand and complain about this other party who robbed me of my business? And again, using the marketers as an example, right? They come in, they build your census, and then they leave. They take all of these patients, maybe coordinators, maybe case managers, maybe the home health aides. They kind of rob your business, but you want to complain, but can you complain? Because you were the one that hired them under an illegal structure in the first place. So it's a horrible position to be in, to feel like you've been wronged, you've been robbed, and yet you can't even complain because you've got some blood on your hands as well. So get a lawyer to talk to you about this before you get into these structures. Okay, termination rights, Charlotte.
I can take this one. So the termination rights, as you see in these bullet points, you have termination for cause and convenience. There's immediate termination under some circumstances, and we will talk about the importance of the cure periods. So starting with the first one, the termination for cause, this is the right to end the relationship when the vendor has done something wrong, such as breached the contract, failed to perform, they violated a law, or otherwise they've given you some sort of legitimate basis to walk away from the contract. And this is a termination right that most contracts include. You should note that a cause-based termination requires you to prove the breach, which can take some time, and it often requires the cure process that we'll describe. If the relationship has simply just broken down, or if you want to bring the work in-house, or if you find a better vendor, this cause-based termination provision does not give you any right to terminate the contract. That's where the termination for convenience comes in. And that's the right to end the relationship for any reason or for no reason. This is typically on advance written notice. So without a termination for convenience provision, you are locked into the contract for its full term unless the vendor breaches. But if you have this termination for convenience provision, you have a clean exit if the relationship's not working, if your agency just needs a change, or if there's a regulatory concern that arises about your vendor relationship, or again, no reason at all. You should always negotiate for both termination for cause and termination for convenience. The vendor will typically resist a termination for convenience clause, especially if they've invested in onboarding your account. But it's a reasonable ask and you should always push for it, and most will agree to it with an appropriate notice period. For immediate termination rights, there are situations when a cure period is not appropriate and the agency needs to be able to exit the vendor relationship immediately. So, what kind of circumstances would warrant this immediate termination? Well, in the home care context, the most common ones are the vendor commits fraud or engages in conduct that could expose the agency to Medicaid liability. The vendor could be placed on OMEG's exclusion list. So it's just at the point where you legally cannot continue the relationship without jeopardizing your own Medicaid participation. Um, there could also be an instance where the vendor discloses confidential patient or business information without the agency's authorization. The vendor could become insolvent or ceases their operations, or any sort of criminal conduct that the vendor engages in. So that's where you want the immediate termination rights.
And just
As,
before we,
oh, go ahead.
oh, sorry. I was going to say before we move on to the next slide, I always think of these disputes with a vendor as writing a story that some judge will later review. The importance of a cure period is that you, as a provider, show that you did try to save the contract and get the work done. Again, I'm not talking about the situations where the law requires immediate termination or withdrawal, but if it's a dispute where the vendor is just not doing what they promised to do and or not doing it well enough, and you've tried to work with them to get them to come around, really, you want that documented because if ultimately you try to terminate before you can, there will be a dispute about whether you did try to save the contract or if you tried to just get out of it because maybe you decided it's an expensive contract for you and you were going to cut your losses. So always think that you do need to write the story of yourself trying to work in good faith, fairly, cleanly, with full transparency and direct communication about where the contract falls short, where the work falls short, I'm sorry, and what you're trying to do to fix it. Go ahead, Charlotte, sorry.
Well said. No, and that's so just a little more off of that for the cure periods. So, uh, typically, do you want it to be within a reasonable time period? So, like if it's a billing error or they missed a report, 10 to 30 days to cure that deficiency is typically reasonable. Um, but also note that the cure period clock does not start until you provide written notice of that breach. So, going to what Amina was saying, you need to document the breaches in writing, specifically what happened, why it constitutes a breach of your agreement, and what exactly the vendor needs to do in order to cure it. Um, and so that's why you also will always see there's typically a notices provision in the contracts as well, where notice needs to be given, and typically you'll send that written notice when it comes to these breaches and when it for the cure periods. And on to the next slide, we have we'll talk about auto renewal provisions. So automatic renewal provisions work like this. It's like the contract has an initial term, say it's 1 year, and then that provides that unless one party gives a written notice of non-renewal by a specific deadline, then the contract will automatically renew for another term, sometimes another year. It could be sometimes multiple years. We most often see that it's another year. Um, the problem is that these deadlines can be easy to miss. So, in your day-to-day operations, tracking the renewal of a vendor contract isn't always really on your radar. Um, and you could have where the contract auto renews because a 60-day notice deadline came and went. And, while management was focused on operations, now there's a contract that you're locked into for another year, and perhaps you no longer need those services from a vendor, and you just don't want to continue forward. Also, there could be times where there's a rate increase that's triggered by the auto renewal. So if you miss that notice deadline, you may find yourself locked in for another year and paying more. So the solution is very simple. You should just know your deadlines and track them proactively. So when you execute one of these agreements, one of the very first things you should do is calendar every deadline that's in the contract. So that's not just the initial term end date, but any notice of a non-renewal deadline, which is typically about 30 to 90 days before the end of the term. We have about
Okay.
6 minutes left, so I'll turn to Amina.
Let's talk about indemnification and limits on liability. So these are pretty custom clauses in most vendor or commercial contracts. And indemnification is a way for one or both parties really to limit their exposure to whatever may go wrong under the contract. So the indemnification will say that each party will indemnify. And so let me translate this into plain speak. They will either reimburse or cover in whole or partially the other party for their losses in the dispute or liability. Let me give you an example. Um, an architect comes in to do the work on a home. There's a contract in place, and the architect says that they will defend the homeowner and indemnify the homeowner if the homeowner or any of the home occupants get hurt by the architect or any of the architect's employees while the work is being done on the contract between the two of them. Uh, Construction is obviously very different than other types of things, but that was just the first example that came to mind. So in this example, the architect is going to carry the cost of whatever losses the homeowner suffers under the circumstances where the architect failed to do something, and that is what caused the loss for the homeowner. So the architect is saying, we're going to do everything correctly, but in case we don't do everything correctly on this project and you, homeowner, have a loss, we're going to cover it. Not only the legal costs that you may have, homeowner, but we're also going to cover what you actually have to pay, whether that's hospital costs, loss of the use of the residence, whatever flows necessarily. And then if the architect wants to say, we'll do all of that, but only up to a certain amount, that's where the limit of liability comes in. So the architect's going to say, we're so great at what we do. We really don't expect that there will be any problems. But if there are, we'll cover you because we don't think we'll make a mistake. But if we do, we will cover our mistake, but only up to a certain amount. And this is what it is. And so it is not unusual in commercial contracts to see a provision that says the vendor is responsible only for the last month's fees that they charged you or for the last year's worth of fees. They're going to cap their damages to some amount, right? They're not going to leave that open-ended. Review insurance coverage because there is a possibility of having tail coverage in some cases. So if there is a purchase agreement and we're dealing with indemnification and limits on liability when it comes to the sale or purchase of a business, the seller is going to want to have some sort of insurance policy for claims that are not yet known to them, but that could come up later because we have a statute of limitations. So just because someone sells a business doesn't mean that they're not responsible for what wrong they may have committed in that business during the 3 or 6 years, whatever the statute of limitations is. So either the buyer, the seller, or both may want to get coverage to cover those old type of claims that could pop up sometime later. And we have to hurry up because we have client calls at 1 and we only have 2 minutes. And I definitely want to talk a little bit about HIPAA and offshore work. So there are a number of laws as well as contracts with payors that restrict where PHI is housed. Obviously, it's somewhere in a cloud, but where is that cloud sitting? Who has control to it? Where are they accessing it from? All of these things need to be addressed in detail, and that access needs to be somehow secured, backed up, duplicated, copied, tracked, etc. All right, that's the long and short of it. Your contract is not just a simple BAA agreement. If the vendor is going to be doing any work, it could be offshore, it could be local too. They need to have more than just a BAA that specifies who is accessing the PHI, what are they doing with it, what is happening with it after the contract is done, how is the provider taking control of it if the vendor goes haywire. Like all of these different contingencies need to be addressed. And then, like I said, the government payor MLTCs, they have their own restrictions on offshore work and having PHI information offshore. Make sure you're reviewing your MLTC contracts because an increasing number of them are asking for compliance certifications about where your PHI is stored and how you're using offshore labor. And then protecting confidential information. We talked a little bit about this at the outset. There's quite a lot of power and information that's being given to these vendors. At a minimum, have them sign a non-disclosure agreement. But an agreement is only as good as it is enforceable. And like I said, if the vendor takes your confidential information, but they are somehow judgment proof, you really have no recourse. So yes, paper yourself and have agreements in place, confidentiality agreements, but at the same time, really question what you give to this outside party that you're bringing in. Yes, you're bringing them in to do something very important for your business. You're paying them a lot of money to do it, but that doesn't mean that they're not going to stab you in the back and misuse it, misappropriate it, disclose it, duplicate all of your secret recipes for your business. And everybody has something, right? A number of you are LHCSAs, but each of you has that one thing that makes you unique. And you have to guard that. That is your business future. Compliance and outsourcing. We talked a bit about this earlier. It is a leadership responsibility. It cannot be outsourced, right? So, yes, you could have someone who is technically not an employee serve in the position of compliance officer, but everything trickles back, and there are so many ramifications for not doing compliance correctly. I really, really shudder when I hear that these duties are outsourced. And then protecting business relationships. There are non-solicitation provisions that we, for our clients at least, all of the vendor contracts that we review, we are looking at how the confidential and business information is being protected. And if the essence and the key asset is relationships, then we are looking to protect relationships through non-competition, non-solicitation, non-disclosure, intellectual property. All of these contractual provisions that are, again, designed to protect the essence of what you as a business sell and make money from. Um, Privilege and sensitive communications, be very careful with what you're disclosing. This is not a cybersecurity or a privacy issue, but it's more of a privilege issue, especially when we're talking about Medicaid billing and integrity. If there are criminal or civil implications for not doing something correctly, make sure you're not making admissions to the bookkeeper, who is doing parts of your LS 300 audit. Make sure that you're not admitting to the wage parity benefit card vendor that you didn't fund minimum wage in a certain year. So just be very careful what you are sharing with these vendors. Your contract by itself does not establish privilege. Privilege only exists with attorneys. Risk mitigation strategies. Conduct due diligence when you are looking at any of these vendors for a potential collaboration. Maintain internal oversight and monitor their performance regularly. And I'm so sorry to rush through all of this. I do have just a few questions I want to see if I can get to. There's feedback and echo. Not sure if it's me. I didn't hear any, and this was a while ago, so it might have been you. Let's see what else. The question is, what about digital marketing agencies who also handle the initial sales cycle? I'm not sure in what context this question is. I mean, it's so a digital marketing agency still involves a human being at some point setting up things, right? But if you're maybe asking about referral arrangements, there's nothing that says that they would not be liable for that as well. Um, the fact that digital marketing agencies generally operate, there are a lot of agencies that operate that way, where they just make calls and they get paid based on the number of calls that they book or more on a productivity basis. I mean, I think that's a factor. That is a factor that I think would augur in favor of saying that's okay. That arrangement is okay. But we would have to look at it in totality. So if you were asking about digital marketing agencies and whether they get around the restriction on paying them per patient or based on productivity, my answer is possibly. It's definitely a newer way to look at and possibly structure a relationship that generally has criminal and civil parameters and restrictions. Someone raised their hand, but I'm not sure if it's one of those Zoom situations where someone's hand is just captured. And my camera, I think, is shutting me off because I've tried to turn it back on and it will not. So with that, I wanted to thank everybody for coming on. I hope this was helpful to you. Please reach out to Charlotte and I if you have any questions after the presentation. And if you would like the slides, feel free to email us and we will send those to you. Thank you again. I apologize for rushing off, but I do hope that all of the content and information we provided is helpful to you. Thank you. Have a good day.